For those that are just joining us, you have Patrick Findaro here with Visa Franchise. Very excited to have on immigration attorney Michelle Canero. We've known each other for quite a few years now, both based in Miami. And the idea was just to have Michelle on and talk about how people can legally reside in the U.S., whether you're already here and maybe you got laid off from your job and you're on H-1B, and what are your options? Or if you're residing abroad right now and you're interested to invest and move here, get a job and move here, or potentially study here, what are your options to legally reside in the U.S., and how can you transition to a green card and eventually citizenship? So obviously there's a lot to cover. If you have any questions, just put that into the chat box. We have Michelle on for almost a full hour. I don't know if it's going to be a full hour that we're recording, but any questions that you have, just put in the chat box. And Michelle, thanks so much for joining today.
No, thank you for having me. Don't say so many years. It makes me feel old.
So yeah, a lot of happy clients. Most of our clients have applied for the E2 visa. However, as we continue to grow our presence, we're getting a lot of inquiries. We've done Ls, EB5 directs, and we're looking to offer support with other different visa categories. And it'd be good, Michelle, kind of as a primer, what are some of the fastest ways for someone that's currently residing abroad to start living in the U.S. and not just come here as a tourist, but start studying, start investing, running a business, working at a business? What are some ways that someone can move here? And it can be some specific countries that have special programs, like in Chile. But what are some ways that people can move to the U.S. fast, or that loved ones can encourage their family to move here? Because oftentimes it starts with someone that's already here, and then want to get their siblings here a lot faster than how long it's taken to get the green card.
So I think it's a complex question, but to try to get to the grain of it, I think, it really is going to have very case specific criteria, and, why are your reasons for coming here and what are your options are going to be largely dependent on your professional background, your education, potential employers, your ability to invest. So, the more factors you have, the more options you have. Some people have very little. Your fastest track right now is going to be a non-immigrant visa. So those are the temporary visas that allow you to come in for a specific reason, and they'll have conditions. Some allow you to work, some don't. They have different timelines in which you can remain in the US and different validity periods of issuance. So the tourist visa is a perfect example. It's a 10-year visa that allows you to be here 6 months at a time. That is a non-immigrant visa. So I think when I'm talking to a client who wants to come and live here, it's implied that they want to be able to work. So while you can get a student visa, and there are some student visas like that have day one CPT that'll allow you to work, or which you can do on-campus work. Some cases you can get a hardship EAD after 6 months. But on the most part, we don't count student visas as work visas, especially from the outset, right? So in terms of visas that allow you to work, one option could be a J1. There's different ways to do the J1, whether it's a cultural exchange program, the au pair program. But the ones that allow you to work would be the au pair and then the trainee visa ones. Lots of options there. Would allow you for 18 months, sometime renewable. Then we have the gambit of H visas, right? So we've got the H-1B for professionals. You need a sponsor for that visa. You have a better chance of getting it if you have a United States master's. Regular, just professionals or people that are using a 12-year equivalency, their lottery chances are about 20%. And there's just this random lottery in April every year, 65,000 spots. If you get selected, you get processed, you get approved. October 1st, you can come if you can find a consulate to stamp your visa. And we're going to talk about consulates because that's a whole other issue. You've also got your H-2Bs and your H-2As, which are shortage worker visas. Companies will ask for a certain number of them. But if you fit a certain profile, there are staffing companies in your country that may be able to match you with an H-2A or H-2B employer. Then we've got the H-3, which I haven't gotten much luck in recent years, but that's going to be like your intern visa if you want to bring someone in for a training program, a short training program, and then go back.
How
You've
is
got your
that different than the J1 visa? Like, why would someone do the H3 versus like the J1?
Because with the J1, you have the skills list, and some jobs are subject to that 212E to your residency requirement. The H3 doesn't have it. Also, some companies may not want to work through a host program. The host programs charge money. So the benefit of the J is that it allows the spouse to work, which not a lot of people know, but it's one of the few, because
That's a big
H1
benefit.
visas don't automatically allow you to work. Student visas don't, there's most of the non-immigrant visas don't allow the spouse to work. We've got the H1B1, which is a shortcut H for people with a Singapore or Chilean nationality. We've got the O's for talent. So if you've got an extraordinary ability that we can document in the arts or business, we can get you a 3-year visa. That does need a sponsor. A lot of people don't know that. So you need a U.S. employer or an agent to sponsor.
And we've seen that with the O1. Like, we've had celebrities, former, soccer stars. And from what I understand, unless they're doing that activity in the United States, then the visa, might not be a good fit. They might not be able to get it. Like, if they just went into business and they were an amazing soccer star in the past,
that's
the one,
true.
I guess, could be a stretch, no?
So the O is going to need the sponsor, and for you to continue in whatever area of extraordinary ability. The O has a green card, like companion, but it's a separate application, right? None of these non-immigrant visas will take you to a green card. As you said, we might touch on the green cards later in the conversation. But the O would be one of those visas, non-immigrant visas, that you could apply for and get in a shorter period of time than a green card. But yeah, it is not, it does require you to continue to work in the field. The interesting thing, though, is that the O1B has been like a great avenue for us to use with chefs, for example, areas that, it's the culinary arts. So that has been one way that we've been able to bring people. Business visas in the O1A category. O1As are harder to prove. That's for science, business, and athletics. It's harder, the O1A, than the O1B. The criteria in the O1B are a little less stringent. L's for multinationals, right? So any client I can get a blanket L for. So that means a large company that's got at least, a certain number of 25 million in revenues in the US, has a certain number of employees, or has submitted a certain number of L's. That's been a great solution for us. And that's primarily because of the consulate issues, right? We're seeing that the consulates are so slow that even if we get an application approved in the US for the client, if they're outside the US, we're still going to be waiting a long time in some cases for an interview to get that visa stamped. We've done Ps. We do Ps for, artists, band members, athletes. And then I love the TNs. If you're a Mexican or Canadian national and you've got certain degrees, it's very degree specific. So you have to be in one of the professional fields in the NAFTA agreement, but TNs have been a great option. And they're finally giving appointments in Mexico for TNs. And in Canada, sometimes we can get them adjudicated at the border. So that, it's a little, again, consular issues taking a long time. Sometimes there's little benefits of these visas. E3s for Australians. I love E3s. Those are super easy. And when we say easy, right, in the world of immigration, there's a list of criteria. And as lawyers, we always document those criteria. But there's discretion of the officer. And sometimes in certain types of cases, the officers ask a lot of questions or exercise their discretion more to the negative side on more cases than one would like. So, cases that have a high threshold of discretion, we've found, depending on training issues or political issues, that we'll see trends in, higher rates of denial. So that'll happen a lot.
I wonder, I don't know if they publish country by country, or I guess they do at the consulate level, like the approval rate for different categories. But yes, I'd imagine like Australia, for example, has like a much higher approval rate across the board compared to Pakistan, where we've had E2 visas from, but like it's very difficult to get approved.
So I also think that a lot of that has to do with kind of the 214B security issues. And what we've seen is in countries where maybe we don't have the best diplomatic relations, or there have been like sort of security risk individuals in the region, or a high profile issue related to people from that region, there is a hesitancy, a much stricter standard that's applied to applicants in those countries. And then we also see that anywhere where you have high volume, right? Like, I think that an H-1B interview in India is probably harder than any other country in the world because of the volume of H-1B applicants they get. I've heard H-1B interviews are supposed to be essentially a rubber stamp, but I've heard nightmares about H-1B interviews in India. I've heard nightmares about student visa interviews in China because there's so many Chinese students, and then there's always these questions of whether or not there's a security risk because of espionage issues and technology. So there's it's often like an undercurrent that will affect adjudications in like a particular visa category in a particular country. Venezuelans, right? I feel like Venezuelans have had a high tendency of denial in different countries, which is unfair because the U.S. consulate in Venezuela closed. So what do they have nowhere to go but other countries. But we've seen some decisions that don't seem to line up with other decisions out of that post. So I think that's part of the sort of strategy you'll work on with an attorney to sort of figure out where you should apply and when.
And then like business owners, so you went through a lot of the options for the employees, the students, and then business owners. You could do the E2 visa if you have the treaty. You invest, 100K, 150K plus, or even
Portugal
potentially an L1. Sorry?
And now Portugal has a treaty, right?
Now
Thanks
Portugal,
to legislation.
exactly.
That's awesome news. And
a lot of Portuguese in Venezuela, Brazil.
Yeah, because there's these Sephardic laws that are allowing them to obtain second nationalities, and with Venezuela, they can't get passports to travel, so they're looking for other nationalities for travel, and these avenues open up. Although,
I think probably with money, and if you have a business in your home country, there's going to be more options, and then the less money you have, and if you don't have a business in your home country, whether it's the non-immigrant or the immigrant path, probably your options get narrowed. Would that be a fair assessment?
Yeah, I think you hit the nail on the head. If you have your own business and you're looking to invest or start a business in the US, you have more self-petition options. Other than that, like that you can essentially sponsor yourself, like with an L with your company, or an E if you have the treaty. You can also do a TN, but H-1Bs, O's, and obviously L's and E's can be used this way too, but are employee visas, right? So that's for somebody that's going to work for somebody else. And when I say E's, I mean E2 employees, right? And L1A.
So that would be like an Italian company that wants to bring over other Italians to work at the business.
Exactly. So you don't always have to be an investor. And that's funny when I talk to clients who have a treaty nationality and they're like, oh, but I don't have capital to invest. I'm like, well, look at your chamber, your country's chamber of commerce in the US, look at job postings, because there are a lot of international companies that use the E2 programs, like Banco Santander. They have it's a Spanish bank. They have a bunch of E2 employees. So we often forget that there are employment options, not just as an investor on the E, but as an employee, and what those avenues would be to knock on doors.
That's something that we've thought about, like building a database of just E2 visa businesses, because essentially if you go to Sunbiz on the Florida website, you can see if it's owned by an Italian corporation, Spanish corporation, and
Correct.
There's a lot of companies that are the beneficial owner is not American. So I can imagine how many, hundreds of thousands of potential E2 visa companies exist in the US.
The only trick is really advising the company that they've got to maintain their E2 nationality, because then what happens is one of your clients who's got all these E2 employees decides they want to get a green card, and then the whole E2 structure dies because they're no longer a treaty national. So you have to do some planning some succession planning to make sure that unless you plan to retire all your employees, that you maintain the nationality to sustain the visas.
And how does it work of like the beneficial owner changes? Like Club Med, for example, they have their North American Caribbean headquarters here in Miami. It's now Chinese owned. I imagine there's still some French ownership, but they were bought out by a Chinese conglomerate. But I think they still have French E2s being sponsored. Like, is that
So,
something that the State Department's looking into on companies, or if it's like traditionally, if this has been a French brand, it's okay and it can kind of fly?
you know, I think with immigration, we hear about these outrageous, like, I don't know, cases. And you're like, never in a million years would that get approved. Well, under the letter of the law, it shouldn't, but that doesn't mean that some person somewhere didn't just approve it. So sometimes things, because, the red tape and a massive bureaucracy of our government can sometimes work in our favor. And that would be one of those instances. Although I'm sure they did some strategy planning where they moved everybody to some sort of a payroll company where there's still a French stake majority interest and did an amendment. I mean, I think that would
Makes
be,
sense.
I think there's probably some strategy there. Although there is the argument that when somebody's I-94 is still valid, not the visa itself, but the I-94, they can continue working and they're in status, right? So even if the E2 originally failed, that individual is not out of status or in violation of status.
It's been only 2 years.
The I-94 will be issued for 2 years.
Is that across the board for every status, or is that just the E2 status that it's for 2 years?
So every status is subject to a reciprocity table. And so the reciprocity table will say how long we will issue a visa for. And then in the statutes, we'll list, so under the Code of Federal Regulations, we'll list the duration of the validity of the I-94 for each non-immigrant visa type. So it's determined by Congress that every time you come in on a B, you can get no more than 6 months. So it's visa category that defines how long you'll be given on the I-94. It's the particular country's reciprocity agreements, treaties with the United States that you'll find on the reciprocity table. They'll tell you how long they'll issue the visa or the FOIL for, which is that stamp in the passport. So that's why like a tourist visa will be issued for 10 years. And then you'll come in and they only give you 6 months. The I-94 that they'll give you is pursuant to what Congress said the validity of that status can be. How long they'll give you the visa for in your passport depends on treaties and what the officer thinks, right? If they think you're a risk.
It could be shorter. You have you could potentially get an E2 visa for 5 years if you're from Italy, but they could give it for less.
Right. If your business doesn't look super strong and it's a startup, you'll often see them kind of treat it like an L and give just 1 year and say, come back and see us, when you're up and running.
And then a big thing we've seen since starting Visa franchise back in 2015 with my brother Jack, we haven't had very many E2 visa renewals. The exception would be for high net worth individuals that for different tax planning reasons, they don't want to get a green card. But we find they always get a green card through the spouse or the investor. And sadly, they get the green card oftentimes later than they should have. For the first clients we had, now we know a lot more, and working with attorneys like yourself, they're able to get the green card faster should that be what they want. But I'd love to talk to you right now, and if you could just open up on, hey, you're already here in the US, you're working at a company, or you're an investor in a company. What are some ways that you can get a green card ideally and not have to wait so long, like with the family partner, the family path where your sibling sponsors you and it's like 8, 10 plus years?
20. Well, there's the lottery. So you can play the visa lottery.
And there's no cost or minimal cost, right?
But only certain nationalities, the diversity visa lottery, only certain nationalities can participate. So,
and there's only certain nationalities that you like actually have somewhat of a chance.
Right. So the lottery's one. And then there's really 2 ways to get a green card. There's some special categories like, asylum. If it gets approved after a year, you can apply. There's there's different special categories, but for the most part, we give green cards for two reasons: family or employment. So family, you're going to have your U.S. citizen or lawful permanent resident parent that sponsors their kids, minor or adult. You're going to have U.S. citizen siblings that sponsor their siblings. And then you have immediate relatives, which would be U.S. citizen children petitioning their parents, or U.S. citizens petitioning their spouse and minor children. And that usually includes your stepchildren, right? So if you marry someone whose kids are under a certain age when you get married, they count as your children, and therefore you get to petition them directly as well. So that's another. So then we focus on employment, right? Because if I'm talking to a client, they usually know if they've got an American who can petition for them. They wouldn't really be bothering me too much if that was what asking me too many questions, if that's on the agenda. Yeah. So, we focus primarily on employment. And there's 5 categories of employment. In each category, there's subcategories. And each category is granted a certain number of annual visas a year. So in the first category, we have EB1. EB1 gets about 40,000 visas a year. And that would be your extraordinary ability individuals. So you'll have 10 categories. You have to document at least 3 of them and show you've risen to the top of your field in the totality of the circumstances. You merit favorable discretion. You want to show that you're going to kind of like you're still going to work in whatever fields, so you can't be like a retired football player and say, I won the World Cup 20 years ago, give me an EB1. They're going to give you your EB1 based on your current and sustained accomplishments. We've got the EB1 for multinational executives. So if you work for a company that is an established multinational that has a branch, either a subsidiary or an affiliate in the United States that has been operational for at least 1 year, and you've been working at the foreign entity continuously for 1 out of the last 3 years in a managerial or executive position, then you can apply for an EB1 to get your green card as a multinational executive if they're moving you here to the United States, either in an executive or managerial positions. That's another one.
Michelle, on the EB1A side, we're recording this January 2023. Spotify announced 6% of their workforce is laid off. Google, pretty similar numbers. So there's a lot of folks that work in technology that had the H-1B, and maybe they've been trying with other immigrant categories that you'll go into. What's their likelihood of getting the EB1A? Like what percent of these software engineers and technologists could get an EB1A?
In the last 6 months, we have seen a massive hike in EB1A denials. Massive.
Is that just because it's like the only option some of them can
industry-wide, we're seeing denials. My theory is it's a combination of 2 things. One, we know that USCIS has been hiring a lot to try to meet its goals for processing. So we have training issues. That's for sure. But in the technology sector, the fact that we're seeing a lot of H-1Bs laid off, and 75% of H-1Bs are Indian nationals, EB1A is the only EB category that is current. So we have a lot of Indian nationals, right? Because as I said, there's 40,000, but there's a backlog for certain nationalities. So what I think is happening is that we're seeing a much higher volume in EB1A applications, premium processed, than we've seen ever. Because if people are getting laid off and this is their only option to self-petition and stay, we're going to see everybody and their cousin trying this, even though a normal attorney would advise, hey, this is not a good case.
Like wait 4 or 5 years, you need to build up your status.
Right, but at this point, people are desperate. So they're like, let me give it a shot. But what ends up happening is we're seeing a very high volume. I think USCIS is seeing a very high volume of applications that A, might not be quality, or B, they look exactly the same. And that's the problem, right? EB1As, they want to see someone special and unique. Okay. If everyone they're seeing is an accomplished software technology data scientist, the same profile, they don't see it as special. It's just rubber
So it's
stamping.
kind of like a university admissions council. Like they're not going to just admit everyone from New York State. If you're talking about Cornell University, for example, they want to have a bunch of countries. They want to have all 50 states if possible. I had some friends at college that were from random, North Dakota.
Listen,
And they said it helped them get in, and I'm sure it did.
I was a Miami Venezuelan girl, and it helped me get into schools in the Northeast, so I get it. But I also think it's got to do with the fact that the category is called extraordinary ability, which by definition means uncommon. So it's like you rise above everybody else. They cannot approve 40,000 people in the same profile or industry and call them all extraordinary. It's not going to happen. So what's really happening is it's having a negative consequence on all applications. I'm right now telling my clients to hold back their EB1s until EB1 India retrogresses. Because once that retrogresses, we'll see a decline in filings. And then the pool of applications that premium processing is processing, we'll see less of that, just like, oh, deny, deny, deny.
And then on the EB1C side, can a business owner sponsor himself? Like, could he technically be the executive or manager at his own business?
Yes, although we have seen USCIS bringing up this whole, like, how can you be a multinational executive and manage your own, be the executive of your own business, because there is this sort of idea that you're an employee. So there are arguments to be made, but I'm seeing that there's some conflict there. The other interesting thing about EB1 is that the policy is you have to have worked for the company abroad for 1 year continuously in the last 3. A lot of business owners abroad aren't on salary. And that's a problem. You have to have a year of documented salary. So, some clients, they've had their companies for years, but they weren't on payroll. So I can't show that they were employed. And that's the definition. So you gotta think about that one when you're advising a client. The other thing is the company abroad has to remain active during the process until you get the green card, because then it stops being a multinational. And what we've seen is a lot of people getting ready to shut down their other company once they come here, and they're like, oh, I got my L and my E, and got my L, I'm going to close down Venezuela's factory, or I'm going to shut down my Argentinian business. And you're like, wait, no, your L depends on it continuing to be a multinational. So but the EB1C now has premium processing.
Tell me a little bit about premium processing. I'm familiar with the concept. I don't know exactly like what the times are like, but why would someone, pay the fee for premium processing rather than wait, X amount of weeks or months?
You want to give the government more money. No. So premium processing, it depends on what your client's timeline strategy is, right? If they have underlying status for years, don't pay it, right? It's $2,500 in most cases. But a lot of clients want to know the outcome of their visa, because that petition or non-immigrant visa decision is going to affect other decisions that they make, right? So if you have to wait a year to find out that your H-1B was denied, you could fall out of status while you're waiting for that, and then you lost opportunity to change status to something else. Or to pursue another course of action. Also, sometimes people want to just do, for example, in green card petitions, there's 2 parts. And there's the petition, like the I-140 in employment and the I-130 in family. But then separately is the green card. If you're here on a non-immigrant visa, as a student, as an E2 investor, and you don't have dual intent, you only want to do the petition and get that approved, because otherwise you won't be able to renew your non-immigrant visa. So strategically, we usually want to premium process those cases so we know the outcome within the I-94 and can renew if we need to. So there's different strategies, but basically what premium processing does is the government charges you more money to do their job in a reasonable time. So on a non-immigrant visa, most of them you'll get an answer in 15 days. Half of the time, it's a request, a stupid request, sometimes
More time.
for more information, a 20-page letter that makes it seem like you submitted nothing, that gets your client screaming, like, did you file anything? But it's just a template made to, make us look bad and buy them more time. We also see it's about 45 days on the new EB2 and EB1, which is great because previously clients would have to wait 2 years. Sometimes on EB1Cs, we couldn't get an answer for 5 years. And since there was no premium processing, I had no way to push an answer. And my clients were on Ls and they're capped at 7 years. So
the companies on both sides, like maybe there was an offer to buy out like their home country side.
Or their L expired and they've been still pending that AOS for years. And I'm like, I still don't have an I-140 approval. So premium processing, I love it. I try to get a decision so I can give my clients a strategy, because my experience has been, especially for people that are in the US, time is the enemy of the immigrant. The longer something takes, the more opportunity is created for things to go wrong.
The doors get shut, right?
Yeah. It's just stuff starts to go wrong and it starts to cost more money. It's just never good.
And then moving on to the next category. So we went through EB1, EB1A, EB1C. Tell us a little bit about the EB2 and what that immigrant visa category is all about.
So employment-based second preference is for advanced degree professionals and exceptional ability individuals. It can be done with a labor certification. So that would be if you are employer sponsored, or it can be done as a self-petition, but you have to argue that you're eligible to waive the labor certification requirement because the work you do is of national interest. And what that really means is that we have to write, after I prove you either have the equivalent of a master's, so I can do that because you have a foreign degree that's the same as master's, or you have a US master's, or we can do a combination of education and experience. So like a university degree and 5 years of experience. We cannot do an experience-based master's. Like you can't do like, I have 16 years of experience, therefore that's a master's. So if we can't do a master's or advanced degree, then we'll argue exceptional ability. And that there's basically 6 different ways to prove exceptional ability, and you have to establish at least 3. The most important, that no matter what we do, if we don't argue it, it's a heavy case, is to show they have 10 years of experience in the field. Then you can have a degree in the field, you could have a high salary, you could have letters of recommendation, you could play a leading role. So there's different ways to show that, not leading role, that you have certificates or the membership. But there's different ways that you can show exceptional ability, and so long as I can document 3, I can classify my client as an EB2. And then it's, am I going to do it with an employer through a labor certification process, which, is really this preamble to an immigration application. You have to do this whole process. The company has to do a whole process with Department of Labor that takes 15 to 18 months, where they advertise the same position. They already know they want to offer the immigrant. They interview all the US workers. They ask the Department of Labor to certify a wage. So there's all these steps they do. It takes 18 months. It costs them money. It's slow. It's annoying. You need to have a really good lawyer that knows how to do it, because it's unforgiving. The slightest mistake, it'll get denied. So, but that's the typical route for people, right? So if you're an EB2 advanced degree professional, you'll usually do a labor certification. Now, you can't do a labor cert if you own your own business, or if you work in a family business, or if you're a consultant, or if you don't have an employer, but you have the opportunity to work and something to contribute. That's where the national interest waiver comes in. And that's been a tremendous visa opportunity for our clients who are entrepreneurs, who are self-starters, because they'll come in, maybe they were on their student visa, and during their OPT or STEM, they set up a company. And now we do an EB2 self-petition. Maybe the person came in on an L with their own company that they established. They want to shut down the foreign operations so the EB1 doesn't look like a great option. Or maybe sales have dwindled and the company isn't as robust as it used to be, but it's still, even though it's low employees, still providing a valuable contribution of some sort and impact to the community. Then we can talk about the EB2 national interest waiver. And the same with my E2s. Most of my E2 investors, either their spouse has gone off and gotten work and gotten sponsored to get the green card, or they do an EB2. Because it's not, if you have a successful business, you're not going to quit your job to go be somebody's employee. You want to run your own business. And that's what we
generally you're making more money already, so it'd be kind of taking a step back.
And there's been, a lot of people were desperate to get green cards and took the chance of, asking a friend to do a labor cert for them. And those cases aren't working because immigration is asking those same questions. They're like, I'm looking at your E2, sir. You renewed it last year. You made $1 million. You expect me to believe you're going to go and work for this guy in a gas station for $50,000 a year? Like,
doesn't add up.
Right. So, the government's still smart. Might be bureaucratic, but they're logical. And so I tell clients all the time, I'm like, listen, if you've got a viable business and you can structure it self-petitioning on an EB2 with a national interest waiver, it's golden. And if you have a degree, and we can argue advanced degree, even better if it's a STEM, science, technology, engineering, and math, those cases have been getting approved with very little problem.
Very cool. What are some things that kind of like boost up the case? Like that they wrote a book, have articles, they have an amazing website. What are some things that can really boost that EB2 NIW case?
I think it's every person is different, right?
Sure.
I think the EB2 NIW, every lawyers differ on how they present their cases and their strategies. And, we do a lot of these now. We've done a lot in the last 2 years. I think our last count, I'm not as prolific as my good friend Carmen, who's amazing at these. But, we've done about 200 of them with like an 87% approval rate.
Solid.
And it's in the last 2 years, we were kind of waiting to see how the Danisar standard played out for a few years, because I didn't want to rush and put clients in jeopardy. We've done a lot of labor certs, so that was always, the route we took with clients or EB1. But with Danisar, it really opened up, and we've seen tremendous success with the EB2 NIWs. I'm just a little old school in that I think every case is different, and I try to tell a story. And the way I see it is this national interest waiver standard is completely subjective, right? It's whether or not that guy in the cubicle in Nebraska or Texas who is not getting paid very well and is looking at a ton of paper all around him. Do I catch his eye, and does he think that what my client does is of, substantial merit and national importance? How do I present that? And every client is going to have their own unique contribution. So qualifying them as advanced degree or exceptional, that part's easy. How I talk about that individual's work and their impact, that's where the case is made, right? And how do I show it is very different. For some people, it'll be letters from very well-known individuals in the field. For someone else, it might be their impact is more social in the community. So then I'm not talking about getting letters from corporate people, but more from community leaders talking about impact. Maybe this person is their contribution is in the arts. The package then would be more visual, and I would try to highlight what that client does to give the reader a sense of connection to my client. Because since it's a subjective standard, I have to appeal to that person's interest somehow. So every case is really different. And I would say the more unique your case is, the more it stands out, kind of like the EB1A, the better chances you're going to have. If your case looks cookie cutter like 10 others that they read last week, it's not going to stand out. And it's going to be, I think, harder to get that petition approved.
And right now, if someone's residing in the US, they could do premium processing 45 days and know the decision on EB1A, EB1C, or EB2 NIW. Is that correct?
Yes. It's awesome.
Yeah.
And then on the EB3 and the EB2 with labor cert, the labor cert's taking about 18 months, and then you can file the I-140 and you'll have a response in 15 days. But I tell clients, you know, if you're going to do a labor cert, you need to have, and you want to do it from the US, you need to have status of at least 2 years when you start the labor certification process, because otherwise you're not going to be able to adjust and continue working. So, you know,
on the EB3 side, like I talked to one franchisee who is in the home care space. He sponsored 60 caregivers from the Philippines and Vietnam, and he loves the program because they stay on for 2 years at like 95% retention, where an American caregiver 50% retention after a month. So he's a huge fan of the program, and yeah, it does take some time, but would love if you could talk a little bit about the EB3 program for those employers that are listening, as well as potential employees that want a job in the US and want to get a green card.
So I think the first thing you've got to understand with all these EBs is there's a big difference timeline wise if you're in the US with a visa and you're abroad at the consulate. Consular processing used to take about 6 to 8 months max from the I-140 approval. Now it's like 2 to 3 years, and there have been rumors of Department of State saying it might take them 5 years to get back to pre-COVID processing.
Wow.
So I warn all my clients, we can do a labor certification process. I love the program. If you're working it with a good lawyer, our statistics of approval on these cases, and I've done thousands, is 99.6%.
I saw I pulled up the list, and you were like one of the top law firms.
Yeah, so Department of Labor disclosure files, it's all public information. I tell all my clients, look me up and look up any other lawyer you're considering to see how many cases you filed and what your statistic of approval is. But yeah, we do a lot of these, and I love them because it is probably the only visa other than an immediate relative petition where the couple's actually in love and they make it to the interview, because sometimes people fight. But it's the only one that I think has no discretion. It's very objective and a very high rate of approval if everything is true and correct and you work with a good attorney, right? Because it is, you do see a lot of denial rates. Like I think, you know, the statistic of approval on a perm is about 90% is what the Department of Labor publishes. That they deny about 10% of labor certs. And then on the I-140 side, I think the statistics of EB3 denials is 25%. So it's really going to take a good lawyer to vet and document everything properly. But once you've got that done, it's very unlikely that you get a denial because there's no discretion, right? It's either the person, it's a real company, it can afford to pay this person, it met the recruitment and did everything in good faith. The foreign worker has the criteria to perform the job and they're not otherwise inadmissible. There is no reason that it should be denied.
So on the non-immigrant visa with, you know, at least 2 years, I can think about the E2, maybe L1, spouses of those petitioners, F1 student visa potentially. Could a J1 work where you do J1?
I've done J's, but you can't start the perm until the person is in the US. Because remember, there's this intent issue. And you can't get a J with the intent to remain in the United States. Sure. You have to be very careful. The person has to get the J, come in, and then they can sign a contract for.
So the employer can test out the trainee. And if there's an amazing fit, then they can make a decision to sponsor the green card.
Right. And then we try to do it within the first month of the J because it's going to take me 15 to 18 months to get the perm approved, file the I-140 and the AOS, and then the EAD is taking a while. So I always tell clients there might be a gap of 6 months where you're not going to be able to work, you know, and that's the reality.
Can you handle that?
Right. And then there's always 212E, but an employer may be willing to take that risk because if they do the process consular, we're looking at 3 years, right? So if you want to use the EB3 program to bring employees, it's going to take 3 years right now to get through the labor certification and the green card process and have that employee here in the US. Might even be longer. So I really advise people to look at other avenues to get people in the US. And, there's now also the parole program, right? Like there's a lot of Venezuelans and Cubans, Nicaraguans and Ukrainians who are coming to the US being sponsored by family, by friends, companies can sponsor, and they're bringing people to the United States. That's a market of workers that have status and workability for 2 years. So that's plenty of time to do a petition.
I like it. Is the EB-4 worth going into?
Well, the EB-4 is a green card for religious workers, and it's the category that's used for special immigrant juveniles. So I don't really think, and I actually think the EB-4 petition part, for some reason, I thought that program was being phased out. So It's not my area of expertise, but I don't think that's really an option.
For this audience, those that are looking to study, invest, work in the US, it's not going to be applicable. And then the EB-5, which is 800K in a certain area, 1,050,000, is an option, I guess, for the people that have the capital.
I mean, EB-5, we talked a little bit about retrogress nationalities. There's certain categories of visas that certain nationals can't access. So for certain nationalities, EB-5 is the best option because it's what's available. Capital wise, thank God that they were a little more reasonable and we were able to negotiate adjusted numbers, but it is a significant investment. And it's not just that, there is the investment if you're going to do the minor, indirect through a regional center, you're going to have to pay the regional center fees. And obviously the attorney fees on these cases are quite substantial. And then on the direct investment, there's the expense of operating the business continuously during the process. And the timelines on EB-5 are very long, but the silver lining, and it's really what saves the program, I think, is that they have now allowed for concurrent filing of your adjustment of status with the I-526. So with the EB-5, for your audience that isn't familiar, you first, if you're going to do it with a regional center or a direct investment, you're going to do an application. It's called an I-526. That I-526, you're going to prove the source of your funds and you're going to submit the evidence of your project. If it's a regional center, if you've done it in a regional center, they're going to give you your I-526 package with all the documents. It's not too much. Where you're really going to have to document, and the work is showing the source of your funds, because you have to trace every single dollar that you invested. And there are accounting standards that USCIS requires, and there's a specific way to document it. So you want to go with an EB-5 attorney that really understands that area. Once your I-526 is filed, historically, you had to wait till it was approved before you could get your conditional green card. Which
I think is like 3 or 4 years right now. It's like
right now it's taking, I think, 50 months for the I-526. So before, people were spending $1 million or spending $500,000 and waiting around for 5 years before they could even file for a conditional green card. That's changed. Now we can file it with the I-526. Once the I-526 is approved, your green card has to be approved, and then the green card has to be approved for 2 continuous years. So if the green card takes more years to get approved, the 2 years counts from the time of approval of the conditional green card. You wait 2 years and you can file removal of conditions, the I-829. That's also taking 50 months. So the whole process is taking about 12 years is what my last calculation. But the benefit has been that people can essentially, if they don't want to invest in a business they have to operate, they can do a passive investment of $800,000 in a regional center.
You write the check and then you start the green card process.
Right. And then you file your I-45. And even if it takes you 12 years, you're comfortable, right? And if you've done your due diligence and it was a good investment, you might even not just get your money back, you might get a return on investment. So for some people, it's just, I have this money available. I don't want to risk trying to start a business, run a business. I don't see a self-petition option. Then EB-5 can be, or they're backlogged, right? I think for Indian nationals, EB-5
I
has
think
been.
right now it depends on if it's a rural zone, India and China, I think is current. If it's non-rural, then it's not current. Like they've like totally changed the chart where there's like now all these categories on the visa bulletin for EB-5.
They're never trying to make it easier, are they?
No. Doors keep closing.
But then some open.
Yeah. Well, Michelle, we have a bunch of questions. We'd love to go through 5 or so. I know we're running up to the end of the hour, but we have Mikey Smith who's asking, what visa would you recommend for someone who wants to invest in the USA and is applying for the first time?
I would ask you what your nationality is. And if your nationality is a treaty country and you have at least 150,000 to invest in a real and operating business that you've already identified, you're going to be able to get it up and running before the interview, then my suggestion would be the E2. But it's really going to depend on what you want to invest in and what your nationality is and what your capital abilities are, right? If you're going to invest in something passive like real estate, I would probably suggest you do an EB-5 program, passive investment, find a regional center where it's going to be in a project that, it's okay that you're not going to operate it. I think it's also going to depend on timelines, right? Certain countries are not issuing certain types of visas. So where an E2 would be great, you're not going to have that option. You have to try something else. So I think that's very case specific, but I'd be happy if you want to set up a consult to go through your options with you directly.
And then we have from Robert, what do you recommend investing in? Any promising industries in 2023? I'll take this. Robert, feel free to browse our sister company, vettedbiz.com. We have thousands of franchise opportunities available there, but big fan of service businesses, especially those that are either very high margin, like think junk removal, or have some recurring revenue that they consistently provide a service to a consumer or business owner. The next is from Kim. What is the best way to begin the immigration process to the U.S.? Michelle, what's the best way for people to get in contact with you? Because every case is unique.
Well, they can email me at michelle@canerolammers.com. We can share my email.
Yeah, we'll include that in the description.
And, I think the first thing to do is you can go on USCIS's website, and they have this kind of neat visa finder portal where you could sort of play around with some of the characteristics of what you want to do here. And they'll sort of feed you potential options. But a lot of the options that we've talked about today are on the website, USCIS website. You can see the criteria, you can see explanations. And I think that's a good way to sort of start, is to look at your options, narrow down what they could be, and then schedule a call with an attorney, because most attorneys will charge you for a consult and you don't want to spend your money hearing the alphabet soup of visas. You could probably narrow down for yourself what you're capable of doing.
Listen to this video and then go on the USCIS site and then schedule the appointment.
I like it. See, the step 1, 2, 3.
And then we have from Travel Vlogger, 2 questions. If I buy a cleaning franchise, qualify for E2? Yeah, we've had investors that have bought a cleaning franchise have been eligible for the E2 visa. A lot of the investment goes into the equipment, marketing to get to that substantial investment threshold. And then if my business required investment, $20,000, can I apply for the E2 visa? I probably wouldn't help you with that because I would have serious doubts of your approval. I don't know what your opinion is, Michelle.
So there's this, you can look it up. It's called the Foreign Affairs Manual. It's this book of the rules and policies that consular officers, which is who's going to decide your E2, use to determine whether or not you qualify for different visas. And there's 9 criteria for the E2. There's 2 very important ones. 1, your investment must be substantial. Now, the Foreign Affairs Manual does not define substantial. They say it has to be proportional to the business, but it also does give an example that a business of $100,000 investment may be considered substantial. This is why most immigration lawyers know from practice, you don't really want to go below 100,000 because they've already set a sort of in their own manual, as little as 100,000 could be substantial. It's, in my experience, it's become the mental floor for most consular officers. Now, there's this very famous case, I think it's called Pollard and Walsh, which was litigated and won by a good friend of mine, Ron Klasko. And this was years ago. And I think he won that E2 because the statute doesn't define substantial. He won that E2 with like a $10,000 or $20,000 investment.
Yeah.
This person invested very little money, let's say in a computer, but created a company with that investment that employed hundreds of people or generated millions of dollars. Then you could argue that that investment was substantial because proportional to the business, that was the only overhead, right? So it can be argued. It's like a unicorn to think that you can do an E2 under 100,000. It's not impossible, but it's very unlikely.
It's going to make everyone's job a lot harder, but you brought up a great point with that case. I mean, if the business is already doing incredibly well, then it's doing incredibly well, and it should be a lot easier getting approved, even if it's just 20K or 30K. But if it's some idea, some business plan, whether it's a franchise or an independent business, I think it's going to be tough.
If you're going under 100,000, you've got to show that that business is profitable. And the other thing that's really important, the second part, is marginality. The business has to be profitable to an extent, or projected to be profitable to an extent that it will do more than just support the family, right? So they want a profitability. They want to see that this company isn't just going to serve your personal interest as the investor. So if you have a minor investment, but a hugely profitable company, then you may be able to argue, hey, my investment was substantial because the overhead to set up this business was minimal, and look at the impact in revenues, profitability, indirect jobs I create for subcontractors. Then you're going to be able to make those arguments.
Michelle, we've gone through a ton today. Thanks so much for those that asked questions. Thank you for all your time. We'll be sure to include the details for those that are interested in scheduling a consultation. If anyone's interested in exploring franchises, we have the largest franchise database on vettedbiz.com. And you can also visit visafranchise.com to learn more about our services. Michelle, thanks again for joining.
Thank you.